weeks.
You know.
All right, gentlemen, thank you so much. Let's move on quickly. It's the season of anomie in Plateau State over the vexed issue of removal of some lawmakers by the court. The 16 lawmakers of the State House of Assembly on the platform of the People's Democratic Party, PDP, who were sacked by the Court of Appeal in November 2023, have approached the same court seeking to set aside its earlier judgment that nullified their elections over unlawful nomination. The sacked legislators insisted that they are still members of the House following the Supreme Court judgment that affirmed the election of Governor Caleb Mothwang, whose case was also nullified at the Court of Appeal on the same ground. In their motion on notice, the lawmakers said, pursuant to Order 6, Rules 1 of the Court of Appeal 2021, they should be reinstated as members of the Assembly. Bikil, how far can they go?
Since we have a lawyer, I don't want to say so much, but if we are to go by history, they are wasting their time. You can't tell a court to reverse a decision that it has taken. Secondly, the matter is statute bad. Electoral litigation are usually time-bound. We've gone past that time now, so you can't go back. You can't go back to and expect that the matter will be retried and then decided in your favor. In any case, the appeal court is the final court in this matter. So, whatever the Supreme Court says, appeal court is the final court in the matter of electoral litigation involving lawmakers, whether at state level or federal level. It never gets to the Supreme Court. In fact, governorship petitions were not getting to Supreme Court before. So this one is supposed to terminate at the level of appeal court. And I do not think that the appeal court will reverse itself. I've not seen a Nigerian court do that. In fact, a Supreme Court judge burst into tears when elderly lawyers like Baba Afe Babalola and Olanekpekun appealed to them or filed an action before the Supreme Court seeking that the Supreme Court will reverse itself. So the woman said she never knew that day would come. She burst into tears because it is even unconstitutional for the Supreme Court to reverse itself. So how do you go before them and say, yeah, reverse yourself? And we've seen people did it and failed. Yari did it, failed. Andy Uba did it and failed. So why do people still keep going back to the court to say reverse yourself over a judgment that you are taken? It's a very predictable outcome.
In a few minutes from now, we'll get some legal aspects or insights to this matter. But before then, Adeoye, like I asked Bikio, how far can they go?
Well, what we can rely on precedents, just like he has said, you know. Apart from the cases he mentioned, we also had a case in the Ekiti State where Shegun also went to court even after the Court of Appeal had declared Fahimi the winner. And nothing came out of it. You see, politicians are die-hard optimists. And I think the lawyers should also be blamed because sometimes what they are doing violates the ethics of law. You know, when the Court of Appeal has taken a decision, it's not right for you to go back to that, you know, the same court as if it's a higher jurisdiction. Unfortunately, the Court of Appeal is where cases like this must end. So for going to court, I think it's just a wild goose chase. It will be so strange if the Court of Appeal will come out to reverse itself. And I will not be surprised if there are sanctions, you know, against the lawyer, because they should have been able to inform and educate the PDP lawmaker that, look, this is not done.
All right, gentlemen, let's get some legal insights into this matter. Joining us for more insights on this issue is a senior advocate of Nigeria, SAN Chino Obiago. SAN, thank you so much for joining us this beautiful afternoon. It's so good to have you on JH on Sunday.
Thank you very much for joining this hangout. I think I'm enjoying the discussion. Even this Sunday evening that we're expecting the Super Eagles to triumph over Cote d'Ivoire this night.
So shall it be.
Yes. Well, I think, I want to zero in from where my colleague stopped. The truth is that any court can overrule itself if you can demonstrate that it acted as Justicia De Vito out of his powers. Supreme Court has overruled themselves several times. Just that some of the cases that have been brought to Supreme Court are political cases, and they are time-bound. So once they are time-bound, why bring it? I mean, somebody brought a case to revisit Imo State governorship election that after 2 or 3 years. I mean, common sense tells you that it was time-bound because every electoral litigation ends at 180 days, 6 months, from beginning to the end. So I think the request by the Plateau State members of the Assembly, in my own opinion, they are taking the wrong route, because if the Court of Appeal had made this decision, and in another matter involving the governor, the Supreme Court made another decision, you are not to sit in your house or in your office to now interpret that, oh, Supreme Court has given a judgment, therefore the Court of Appeal earlier judgment is a nullity. That is really a rascality, and it doesn't hold water. What they could do, if the law permits them, is to go and start afresh and ask High Court to give the Court of Appeal to give effect to later decisions of the Supreme Court. But they cannot do that, unfortunately, because it's an electoral dispute, and the electoral dispute is time-bound. So, unfortunately, the case is closed, in my own opinion.
Now, you said you suggested that they should go to the High Court. They should start afresh. Well, that's an electoral matter. What will happen?
No, not the High Court. I didn't say. No, sir. I didn't say the High Court. They could go. They could revisit if it's not an electoral matter. It's an ordinary matter that is not time bound. They're talking about a court revisited the earlier judgment.
Okay.
They could, if it's an ordinary matter that is not time bound, as an electoral matter regulated by statute, they could go back to the Court of Appeal and ask the Court of Appeal to revisit its judgment based on the recent development in the law, or the law as it was at the time the decision was given. But I'm saying that this particular case is an exception, because it's an electoral litigation and it is time bound.
Yes.
So they cannot do that. So speaking generally, courts generally has the power to revisit its own judgment if there is a reason to do so. But when it comes to elections, you can't do that in Nigeria today, because the Electoral Act 2022 specifically set a time frame for electoral litigation to end. Someone raised the issue that even governorship elections go to the Supreme Court. Yes, in a pre-election matter. Remember, the Electoral Act distinguishes pre-election cases from electoral disputes. So when it has to do with the pre-election, which you must file at the lower court within 14 days, then it can get to the Supreme Court, because it's purely pre-electoral matter. But if it's a post-electoral matter, no, it terminates at the Court of Appeal when it comes to state governorship or House of Assembly election.
Now let's talk about something that came out of that judgment, this Plateau judgment and the Supreme Court. That is the distinction between a pre-election matter and a post-election matter. The matter of nomination or sponsorship of candidates, where the candidate is not validly nominated by his party. Isn't that both a pre-election and a post-election matter? Because I know in law, You lawyers will say you can't build something on nothing. If someone was not qualified ab initio, can't it then be seen as both a pre-election and post-election matter, and then it gets dismissed? Can't that happen?
Yes, that was happening before the amendment. Now, the Supreme Court has said, even recently, in Atiku Abubakar and Obi versus Tinubu, that if you want to question qualification of a candidate, you should do that as a pre-election case. You can't bring it as post-election. Since 2019 or so, the Supreme Court has made that distinction. I'm not here to discuss the decisions of the Supreme Court on electoral cases. We always say that the Supreme Court should abstain from certain electoral disputes because it's not good for our judiciary, frankly speaking. But before now, if you are not qualified, qualification of a candidate was a ground to challenge an election at tribunal. But the law is shifting gradually that if you dispute qualification of a candidate, they should do that within 14 days of the primary as a pre-election matter. If you bring it as a post-election matter, well, it's neither here or there, it's buried. So it is safer to. So when you bring it as a pre-election matter, then the appeal can move on up to the Supreme Court. But if it's a post-election matter, which is deal with electoral conduct and all that, then he has to stop at the Court of Appeal for governorship, State House Assembly, and even National Assembly elections.
Can the Supreme Court, for example, having given that judgment, is there anything the Supreme Court can do to help these 16 lawmakers? Because they are hinging their agitation on the pronouncement of the Supreme Court, which set aside the disqualification of the state governor on a legal matter that is quite similar, if not the same, to the matter of those 16 lawmakers. Is there anything, can they approach the Supreme Court, for example, to say, give maybe a consequential order or something that can? I'm just looking at what can be done.
The simple answer is no. It's an impossibility. Court deals with parties before it. So if the 16 or 19 House of Assembly members are not party to a dispute in the governorship election, God cannot give a consequential order for parties that are not before it. So he can only give all that respect to the case before it. The Supreme Court will not be going about looking for, I gave a decision, so who had similar dispute? Can I apply my recent decision to your dispute? No, you can't do that. And that's why I said if it was a general litigation, then they could go back and ask the court to interpret. Exactly. They cannot do that now because you have to come before the Supreme Court. You have to be a party there before you can seek any relief. And unfortunately, they are not. So as far as electoral disputes, electoral litigation is stand bound, like you earlier said, and I agree completely.
Now, your position is very popular among senior lawyers. But why is it that we still find some lawyers who know this fact, but they still want to go ahead, by standing in for the lawyers for the PDP lawmakers to take the case to court and defend them, when it's so clear in law, as you have stated very clearly? What must have encouraged these lawyers, to encourage these lawmakers that, look, they can still go ahead? What are they looking at? Is it litigation fee? Is it?
Well, Alex said, No, I earlier said this was my personal opinion, and where two lawyers are doing cases, there are two different opinions, and there are two different approaches. Now, I've not read the facts of the case. Maybe if I read the facts of the case, I may see a gap, I may see a leeway, I may see a prayer that raises such possibility. I've not seen it, so I cannot say, advise on what I've not seen. I express an opinion on facts that I'm not well acquainted with. But having said that, we are called as lawyers, especially those in private litigation, to interrogate the case, of your client, to a logical conclusion. That is our brief. And a lawyer will check on his responsibility, his or her responsibility, if he forecloses the case of a client. If there is a small gap, a window of opportunity to exploit. And then, of course, when you exploit the court, you're also enriching the jurisprudence. So the other case you mentioned, where the Supreme Court imposed costs on a senior lawyer who brought a case before it, my opinion, well, some of us say it's completely unnecessary. Because how do you expound the law if lawyers didn't go out of their way to interrogate certain positions? Nothing is cast on stone. We are told in law school, you can always interrogate any legal position. So I'm not going to blame anybody who sees a gap in a case and says, can I for that? All the court can do, sorry, don't have jurisdiction to do, we don't have jurisdiction, and the case is closed. So it's neither here nor there. Maybe if the case comes before me, I can do the same thing if I see any gap. And that's why we read our briefs and read the room very closely, because we play on the weakness of the other side. So when you see weakness on the other side, go ahead and do it. But the facts as put out in the media, which I've read, in my opinion, I think they cannot go back to court of appeal, to ask the court of appeal to use the decision in the Supreme Court in another case to now reverse itself. No, it's not done. In my own opinion.
All right. SAN, if you were to advise these politicians now, what would you advise them to do? And what are the lessons for politicians?
Oh, I think I will start with the last question. Frankly, lessons for politicians. For us in the justice sector, electoral dispute has stopped by the judicial system, I must say so. And we have advocated that Nigeria is just one out of very few jurisdictions where electoral disputes are litigated even after the swearing in of the incumbent. There is no reason why we should have 180 days to resolve electoral disputes. Instead that we can use alternative methods to resolve electoral dispute, recount the ballots, go back and look at the qualification if it's being checked. The person doesn't have school start. Okay, bring your school start, let me see. I mean, we can set up a panel and within 7 days, every electoral disputes are resolved. Because when you throw this into the court, I tell you what it does. It messes up the court system. All the other cases are stayed. Nobody heard. In fact, now, court are recalling cases adjourned since 2022 because they have to wait to finish electoral matters. And at the Supreme Court, you saw the statistics, 1,650 cases came to Supreme Court electoral matter arising from 2023 elections. Supreme Court alone. So the influx of litigation, electoral litigation into our judicial system is overheating the system. Judges can no longer do anything apart from electoral matters. And like you said, frivolous claims go to the courts. So my advice to politicians is to look inwards, increase political party internal democracy, and create dispute resolution system within the political parties. A dispute resolution that is capable of being recognized by the court. So if there is dispute about primary election, the court will ask, what has PDP internal dispute resolution system said? Oh, what did your arbitrators say? The court may be guided by that. But when you throw everything into the court, then it does not do well for the country and for the justice system. And specifically for the lawmakers who are trying to reclaim their mandate, I think they should revisit the question again and to see that, it's an electoral dispute. And the Electoral Act is clear about that. It is time-bound. I'm not sure they can do that successfully.
Right. We must thank you, Senior Advocate of Nigeria, SAN Chino Biago, for joining us on Journalist Hangout on Sunday. Thank you so much for your legal perspective on the program today. Thank you so much. Thank you for your time.
Thank you very much.
Please enjoy the rest of your day. Thank you. There we have it. Now.
It's, I have my sympathy for them, but this whole thing happened because the PDP didn't put its house in order. PDP members, people belong to the Jerry Husseini faction, were the ones who went to court in the first place to say, look, the Congress of the party was not conducted in a valid manner. And the court gave an order, which the court insists they did not obey. The court insists that his order was not obeyed. You know, that is with respect to organizing congresses. They claim that they indeed organized Congress, but the court claimed that it did not get any correspondence, any notification, and INEC did not supervise any Congress. So this was what the lower tribunal as well as the appeals tribunal used to invalidate the candidacy of those people after they had already won the election. Some of them won by landslide. You know, so politicians need to learn. When Rotimi Amechi didn't obey court order in 2019, 2018, all of the APC couldn't produce a single candidate in Rivers State for the 2019 elections. You know, and the Supreme Court validated that. So you must obey the court. If the court says go and do Congress or go and do primaries, you must obey the court. Now they refuse to obey the court, and see what has happened. They claim that they organized this, but the court said it was not aware. Very sad. So I pity. I have friends among those who have been sacked, and these are very good politicians. Popular. Look at the former governor of Plateau State. Lalong was well beaten, but today Lalong is back in the Senate, not because he won an election, but because the original winner was disqualified. So it's very sad. I hope that politicians will learn, but it's always difficult for them to learn. That's the most important. Thank you.